Good afternoon, everyone. Welcome to our webinar today. My name is Chrissy Blouse. I'm an attorney at the Women's Legal Center, and I'm just going to be giving you a few of our logistics for this webinar before I hand over to Ziona to officially welcome and introduce the session today. So we will ask that throughout this webinar, everyone's camera is switched off and mic is on mute, just to allow the smooth facilitation of the webinar and for any connectivity issues. Every panelist, when they are addressing you, they will turn on their own video camera and unmute themselves. If you have any questions, comments, anything you would like to add to the discussion today, please do so in the chat box. We will be facilitating and monitoring all questions and comments, and we will be raising them with each panelist individually as they are addressed to any particular person throughout the webinar. We know that more people will be joining, and we will allow people to join as they do come onto the webinar today. And further on, I would like to ask Sihona just to introduce the webinar today and welcome you all here.
Hi, good morning, good afternoon, everybody. We're so glad you could join us here today. My name is Ziona Tanza. I work for the Rule of Law Department of the Solidarity Center. On behalf of Solidarity Center, Women's Legal Center, and SERI, we would like to welcome you to our seminar on engaging the courts to further worker rights, Mahlangu and beyond. But for those of you who don't know or haven't read Mahlangu judgment, it was a judgment given by the Constitutional Court last year. We had found that the exclusion of domestic workers working in private homes from claiming compensation for occupational health and injury was unconstitutional. So, but the judgment was really, for those of us who had been involved in this case, we were taken aback by how far the court went in sort of bringing intersectional analysis into anti-discrimination jurisprudence in South Africa. Now, South African law was already progressive in its anti-discrimination jurisprudence. So one of the things we wanted to sort of discuss in the seminar is where does Mahlangu take South African jurisprudence? And also the beyond, we're looking beyond South Africa, we're looking at an inter-American court judgment as well. And we're looking at a series of cases in the UK, which also involve worker rights involving courts. So I'm just going to quickly give you an overview of who's going to be speaking today, and then I'm going to hand over to our moderator, Chrissy Blouse. So we're going to start off with SERI. We're going to have Kele Kuno, who is a researcher there, who will take us through the advocacy and the approach to litigation that SERI adopted. Then we will hear from the two domestic worker unions. We'll hear from Myrtle Witbooi of Satsawu and Pinkie Mashiani of UDWOSA, who was formerly of Satsawu, and they will explain the process of engaging courts, what it entailed, the impacts and the outcomes, the costs and the benefits of engaging courts. Then we're going to shift gear, and we're going to hear from Professor Kathy Albertine of Wits University, who will explain to us where Mahlangu fits into South African jurisprudence and so the advantages and limitations of using intersectionality as a strategy. We will shift gears again, and we're going to hear from Natalia Brigagio, who is a brilliant Brazilian human rights lawyer, and she's going to describe for us and explain to us a case in the Inter-American Court, which also adopted an intersectional approach to adjudication and dealt with factory workers. Our final speaker is going to be Manoj Diaz-Abi, and he's from the University of Bristol, and he is going to tell us about his research into small unions, small weak unions in the UK, consisting of Uber drivers and migrant workers who have engaged courts extensively. And he'll also analyze both the costs and the benefits of engagement with courts in that circumstance. And so with that, I'm going to hand over to our moderator, Chrissy Blouse from the Women's Legal Center.
Thank you, Ziona. So as Ziona mentioned, we're going to have our first speaker, who is Bucheli from the Socio-Economic Rights Institute based in Johannesburg. SERI was the legal representatives for Mrs. Mahlangu, and they're going to give us an overview of the legal strategy they adopted throughout the case. Bucheli.
Thank you very much, Chrissy. I'm just going to share my screen. Chrissy, can you let me know if you're able to see the PowerPoint presentation, the slideshow presentation?
I can see it, yes.
Perfect. So just a few logistics, but my internet connection is quite bad. So please, Chrissy, if my internet's buffering too much, please don't hesitate to let me know, and then I'll switch off my camera, and we'll do this over just audio. But as Chrissy mentioned, my name is Bucheli. I'm a researcher at the Socio-Economic Rights Institute. And the purpose of my presentation today is to give an overview of the Mahlangu case, the Matlanku versus the Minister of Labour matter, which Ziona gave background to, was basically culminated in a groundbreaking constitutional court judgment in November last year. So I'll just be talking about the context, the context of domestic work in South Africa that informed the legal process. And I think later on we'll hear from some of the people who have been really involved for decades in this process, namely Ms. Pinkie Mashiani, as well as Ms. Myrtle Bitboy. So just to start us off, I think this when we talk about the exclusion of domestic workers in Koida, and this very important case, Mahlangu versus the Minister of Labour, I think it's very important to remember that the tragedy behind this case. And for those who don't know, who haven't been following the case, what happened was that on the 31st of March in 2012, a woman by the name of Ms. Maria Mahlangu, who's a domestic worker, died at her workplace at the home that she was employed in Pretoria. And when her daughter Sylvia sought compensation, and Pinkie will tell us a lot about what was actually happening in those months following the death of her mother. She essentially was told that because her mother is a domestic worker and domestic workers are not covered by the Compensation for Occupational Injuries and Diseases Act, the family would not be compensated for the death of their mother. And so essentially, if we think about it, had Maria been a nurse or a teacher or any other worker that is formally recognized, her family would have been able to receive compensation, or at least have the opportunity to claim for compensation. And another thing to remember when we talk about this case is that even though we know about the story of Maria and Sylvia and this journey that they have walked, we need to remember that there are many domestic workers who, including drivers, including gardeners, who did not actually receive any justice for any injuries, diseases, or even death at the workplace. And so that's why this case is very important, is that there are many, many, many domestic workers whose stories we haven't heard, who have suffered injuries and were not compensated by virtue of being excluded from a social protection like Koida. So the fight for inclusion in Koida, I think, if Mayor Myrtle can tell us about the history of Satsao, but the domestic workers have been very involved in the worker movement in South Africa. And from the 70s, 80s, 90s, this fight to be included in labor protections such as Koida, which was then called workmen's compensation, has been a conversation that unions have been advocating for a very long time. And in the early to mid 90s, domestic workers were then recognized as workers and then included in labor laws such as the Basic Conditions of Employment Act, the Labor Relations Act. But there were two very important laws that they were excluded from. The first was Koida, which is the topic for today. And the second one was UIF, the Unemployment Insurance Act, which provides for the UIF, the Unemployment Insurance Fund, where workers are able to claim in times of unemployment or for maternity benefits and other benefits. And so these two laws, domestic workers were excluded from. Whilst the efforts of domestic workers, unions, and other organizations that are allies to domestic workers, while they were able to really have this profound achievement in essentially attaining the inclusion of domestic workers in UIF, which was around 2003, in the early 2000s, this fight for Koida has been going on for a long time. And I think it's been a conversation, and I think it was something that was acknowledged by the Department of Labor, the need to include domestic workers in this very important law, but there's been a lot of conversation about it and not so much action on the side of the Department of Labor. And finally, after many efforts to fight for this inclusion, in my opinion, prompted by the fact that this legal case was gaining momentum, the Department of Labor then announced in late 2018, that the amendment process to include domestic workers in section 1 in the definition of employee in COIDA it had that in its plan. And so we see that whilst we were beginning this case or gaining momentum in terms of the Mahlangu case, this conversation, or concurrently this conversation about the amendment of the act, was always there. So they converged. However, the key difference was that on behalf of Ms. Matlanku and on behalf of SATSA, which was the second applicant in this case, we were not only looking for the amendment of Section 1 of COIDA, we were also looking for so basically, when Section 1 is declared as unconstitutional, this exclusion of domestic workers from the definition of employee, we wanted that declaration of constitutional invalidity to apply retrospectively, which would mean then that all the domestic workers, drivers, gardeners, anyone who falls under the category of domestic work, who has experienced an injury or has contracted the disease or even died between 27 April 1994 and basically up until a certain point, which I think the Compensation Commission has revealed that the basically 20th of November, the day after the Constitutional Court judgment was handed down. So anyone within that period who had been injured and because they were excluded from this law were not able to claim, would be given the opportunity to lodge a claim. So that was the key difference in what was going to be a very well-run parliamentary process, which has already begun, and I'll speak about it a little bit more. That was the key difference between that process and why we were actually going to the courts, because there was a very important component that was not going to be included in the amendment, and that's the issue of the retrospective application of the Constitutional Court order. So this has been a process of many years. But on the 23rd of May in 2019, the North Gauteng High Court heard the case for Matlanku versus the Minister of Labor. And later on in October, the court basically, let me just backtrack. So in May, the court was able to hear this matter and declared that the exclusion of domestic workers from COIDA was constitutionally invalid. Later on in the same year, in October, the court then handed down a second order of declaring that the constitutional invalidity must be applied retrospectively to provide relief for domestic workers who were injured or had died prior to the granting of the order. And what's really important about this aspect of retrospectivity is that on the respondent side, while the respondents conceded that the inclusion of domestic workers in COIDA was very important, one of their arguments towards perhaps limiting the retrospective effect of the order was the administrative and financial burdens that the compensation fund would face should this be opened up. And as we'll see in the Constitutional Court judgment, for those who have read it, it was the evidence that the respondents gave in terms of this idea of an administrative or financial burden was not sufficient to convince the court that to limit the retrospectivity clause. And so then on the 19th of November, we have this groundbreaking judgment with the Constitutional Court declaring the constitutional invalidity of Section 1, subsection 19, paragraph 5 of COIDA, which previously excluded domestic workers from the definition of employee. And it ordered as well that the order of constitutional invalidity is to have immediate and retrospective effect from 27 April 1994, which then means that those domestic workers who were injured or the families of those domestic workers who have died are now able to put in their claims. But the title of this this entire webinar is beyond Mahlangu, because we know that even though we were able to achieve this great victory through the work of many domestic workers, unions, and organizations, the real work is only beginning. And so what has happened post Mahlangu was that to be able to actually understand what the process of claiming a retrospective claim actually entails, and of course to support our client, Ms. Matlanku, who has a retrospective claim. In the days after the Constitutional Court judgment was handed down, we actually put in a claim for Mrs. Matlanku's mother's death. And that has been able to, it has helped us to basically see how practical or how domestic workers from South Africa who have these claims would be able to go through this process. And so, as I mentioned, the amendment process for COIDA was underway as the court case was being done, and in early January, so in this year, this process really picked up. From our experience with the retrospective claim that we're following, we were able to identify several sections in COIDA that actually make it very difficult or even impossible for a retrospective claim to be processed. And so in the submission process, we were able to, alongside many other organizations, I know the Women's Legal Center also put in a submission as well as an oral submission. We were able to really try to ensure that domestic workers have the full protection under COIDA, and that the Constitutional Court judgment is really fulfilled through this amendment process. What has also happened subsequent to the judgment was that the Compensation Commissioner in March issued a notice to domestic worker employers, basically giving them instructions for registrations, as well as essentially putting in a clause or a condition for retrospective claims. And essentially what it says is that retrospective claims need from 27 April 1994 need to be put in, or note the Compensation Commissioner or the employer of the domestic worker who's affected, they need to put in these claims before the 20th of November 2021, which is a year after the Constitutional Court judgment was handed down, which we really believe is unreasonable. It's an unreasonable time frame for a worker group that we know has been historically disadvantaged, and it's a very short time frame for with the fact that we haven't actually really heard any drive to educate domestic workers about this law and give very detailed information about the process of actually putting in a retrospective claim. It's very encouraging that we were able to
Bucheli, can you hear me? It seems like her network has some connectivity issues, as she mentioned at the beginning of the call. I'm just going to give her a second to see if she comes back in. Okay, so I think we've lost Bucheli due to connectivity. What I think we'll do is we'll go on to the next speaker, and should she come back on, we'll maybe give her a chance towards the end just to finish either her presentation or do some final concluding points if she needs to. But our next speaker is Pinkie Mashiani, who is a former organizer of SETSAWU, now the founder and president of the United Domestic Workers of South Africa. She's also the person who first met with Ms. Mahlangu around 2012 and had been walking alongside her within her journey litigation until its judgment in the Constitutional Court last year. As Bucheli has highlighted to us in her presentation, we've had this great judgment that was declared the section unconstitutional and now has retrospective effect, but the practicalities and implementation thereof has proved to be quite difficult for many of the other domestic workers and vulnerable workers, which would fall into the similar categories in accessing the social security and rights. And so what we would like for Pinkie to do is just to give us a background of the Mahlangu case from the lived reality perspective, what struggles Ms. Mahlangu endured in accessing the Department of Labor, accessing her social security rights, and then accessing the courts. Pinkie?
Thank you, Christy. I'm also, actually, I want to say I was also awarded a scholarship by Nelson Mandela Foundation and Atlantic Fellows for Racial Equity. So I'm a 2020 cohort. I want to put it clear that it was not the case of Maria Mahlangu that made me to look for justice for domestic workers. It was the cases that I read about before even I saw the story of Maria Mahlangu on a newspaper here in Pretoria. Like Bucheli said that there are many domestic workers who died even before Maria Mahlangu. Comrade Merkel can bear me witness that there are so many domestic workers who died in the line of duty. So before I saw the story of Maria Mahlangu, I was touched by a story of Agnes Mngadi. It was somewhere in 2000. I also saw it on a paper, where a domestic worker who was employed by 2 police officers, and on the following day when she was going to her new employment, it happened that, I don't know, maybe it was accidental that the employers didn't lock their dogs. When Agnes opened the gate of her employers, she was attacked by dogs, and so viciously that she was in coma for 4 days. After regaining consciousness, she had a heart attack, according to what I read in the newspaper. Because of all her injuries, after she saw them, she had a heart attack and died. That was in Durban, KwaZulu-Natal. Then after that, again in 20 something, before the case of Maria Mahlangu, I also read about Christina Mario. It was a domestic worker here in Gauteng, Johannesburg, who was from Alexandra and working for employers in Randburg. Christina Mario was looking after the employer's house while they were on holidays in December. It happened, according to the newspaper, that I still have a copy of it even today, that on the 29th of December, they broke into her employer's property. Christina was raped in front of her 4-year-old daughter, Tinti Lerato Moya. Her throat was slit in front of that child. They cut off electricity. They cut off the telephone, landline telephone. So the employers came back on the 4th day, on the 1st of January. When the employers got there, they found Tinti Moyo seated next to her mother's decomposing body. They called the police, and when the police asked Tinti Nana what happened, she said, "My mother wouldn't wake up." Those are the stories that hurt me so much. Because of not having resources as domestic workers, I couldn't follow those stories. I couldn't afford to follow those stories. So in 2012, in April, while I was reading a newspaper here in Pretoria, Pretoria News, I saw a very short article that a domestic worker is drowned at a house in Ferryland while working. And I said to myself, this is the time to stand up and do something, because now it's local. I don't have to travel far away. Firstly, I knew that domestic workers were discriminated. I didn't know about the unconstitutionality because we are not well educated as domestic workers. But one thing for sure I knew is that domestic workers were discriminated, and I knew that domestic workers have rights. I knew that domestic workers are protected by constitution, because at least I have constitution, I have the labor laws that I was reading about domestic workers. So I knew that something must be done, and that was the time for me to stand up. When I told the domestic workers in our meeting that there was a domestic worker who died in Perikland, I asked them to locate the employers. They found the employers on the next meeting, and the following meeting in July, I asked them to in July, I asked Mpumalanga. Those from Mpumalanga came back and told us that they found the family of Maria Mahlangu. I phoned them and made an appointment with them. I asked them to come to our meeting. I remember it was the 19th of August 2012 when I first met the family of Mahlangu. That family, all of them, even Sylvia, they didn't know anything about the law. They have accepted the passing of Maria, and that Maria has passed away. They have buried her. They didn't know anything about UIF or compensation fund. I told Sylvia to go to Department of Labor because I wanted to have a strong case that she started there. I said she must go to Department of Labor to find out about her mother's UIF, because I knew that they were not covered by compensation fund. When Sylvia went in Mpumalanga UIF, they said she cannot get UIF because she was over age. I also knew that because Sylvia was no longer a student or a tertiary, and she had already had her own baby, she was no longer covered by UIF. Even if Maria Mahlangu was registered with the UIF, she was going to compete. So after Sylvia has gone to Labor Department, started to make appointments with her to come. The first place that we went to together with Sylvia was the University of South Africa, because that's where I had hopes that these institutions are the ones that they will help the domestic workers to get justice. When we went to the University of Pretoria, University of South Africa, UNISA, we were met with a defiant attorney, Gandhi, I still remember her, who said that was not anyone's fault, it was not employer's fault. So I said to her, yes, I know that it's not employer's fault. The employer didn't push Maria into the swimming pool. But I also saw that the swimming pool was covered by a net now, explaining to that lawyer that it shows that the employer knew that Maria couldn't swim. And if the employer has closed that swimming pool, Maria maybe wouldn't have drowned. And I also said the government is discriminating the domestic workers. I beg your pardon, actually, I didn't start at UNISA, I started in Equality Court, not knowing that this case was going to go to Constitutional Court. In Equality Court, I went there because of thinking that domestic workers were discriminated. So I was going to ask the Equality Court to look at the case, of which I was told that the case doesn't fall in their jurisdiction because I was talking about the government and the domestic worker. Then we went to Magistrate Court, opening a criminal case because I believe that the employers were supposed to go to court and give their side of the story that how Maria drowned. From there, I went to UNISA. I was turned down by UNISA. That attorney can even send me a letter of refusal that I still have until today, that they cannot assist us with our member. From the University of Pretoria, we went to Legal Aid South Africa, where we were also turned down. We went to the university. From the University of South Africa, went to Legal Aid South Africa. From Legal Aid South Africa, went to University of Pretoria, where they didn't even want to listen to our story. They just said to us, I was with Sylvia all along. Write what you are saying here, and you can please write it down and leave your numbers, we'll contact you. And I said to Sylvia, they are not going to contact us. I saw that lady was saying this. Then from there, the first person who understood what I was saying was Nhlanhla Mabizela from Solidarity Center. Even the comrades that I'm working with, some others didn't take me serious for this case when I started with it. So Nhlanhla, when I approached Nhlanhla, that I was turned down by UNISA, I was turned down by Tekis University of Pretoria. She said to me, Pinkie, I'll speak with Ziona, our lawyer who's in America. I'll tell her about your case, but I'll also give you her email address to contact her. Then the next thing we agreed with Tlatla that we'll go to Wits University. That was the first institution that took us seriously, the Wits University, where we met senior attorney Nkosi. We started with a case of Maria Mahlangu there. Then Attorney Nkosi took us to Sentin, where we met our first advocate, Pillay, where Advocate Pillay explained to us the strength of the case, how massive the case was, and that the case was going to change the law in South Africa, and it's going to be called the Mahlangu case, of which yes, today it is called the Mahlangu case. Then after that, I wrote some emails to Ziona speaking about the case with Ziona, and through her support, we pushed the case. When Senior Attorney Nkosi left Wits University for SERI, I went back to Ziona and she told me that Nkosi is with SERI now. Ziona made it possible for us to meet with SERI. With Sylvia, again, we went to SERI. By that time, Sylvia was pregnant with her second baby when we went to meet SERI. There we met the lawyers from SERI, Nomzamo and Nkosi. So then they asked us to go and close the case with Wits University and asked us to hand over the file. That's what we did with Sylvia, and then the case started. At SERI, we saw the case now moving forward. The first date we were given was the date of the 15th of November 2018, which was postponed by the Minister of Labour. We went to court for that case. Cape Town was here, members of SATA were together for the first time, seeing that there's something that is happening in a case of a domestic worker. So then we were given another date, like Kilebogila said, in May, the Pretoria High Court said it was unconstitutional. As unions, we knew that COIDA was unconstitutional during that time for all the years that we've been fighting for domestic workers. And the only thing that we didn't have powers and everything to confront the government. With the help of SERI, we did it, and Solidarity Center, of course. The case saw us in the Pretoria High Court, where we were victorious in May. Then we went to Pretoria High Court again in October. That the ruling was declared by the second court, and it was transferred to Constitutional Court that indeed it must be declared by the Constitutional that COIDA is unconstitutional. That's when we went to COIDA the following year, 2020, January 10, when we went to Constitutional Court. To be honest, when we entered there, I want to speak about me personally. To see all the 10 judges seated there for a case of a domestic worker made my body, I had goosebumps. I couldn't believe that this is that case that started in 2012, that case that nobody took serious, that case that people were thinking that I'm crazy when I was talking about. There's put the High Court, the Apex Court, Constitutional Court judges, 10 of them sitting there, and hearing Advocate Khumuzo Moroka speaking about Mahlangu there. I remember that I was recording with my phone, and she was asked a question by the judges that if Mahlangu was alive now, what would have been happening? She said, I remember her answer, she said, Mahlangu being alive, she was supposed to, if I'm still remembering correctly, she was supposed to be covered by law as by COIDA, Compensation Fund, yes. So from there, it was lockdown. There was, everything was put to a stop, and we waited from SERI until we got the date again on the 17th of November. We were told in a short notice that it is the date on the 17th of November. I was told by Attorney Nkosi, of which it was so great to hear that we are going for the second time. And we're waiting to hear, because I remember Judge Mokoeng telling the lawyers of the government that you are here for us to give you the direction. He was even questioning him about the time frame, how long the government will take to include domestic workers, and how long will the process take. He was questioning that the minister's advocate. I remember those questions. I've sent them somewhere. So going there on the 17th, I want to be honest, I didn't know that that was the ruling day, but we went there victorious. We knew that as long as the High Court has declared COIDA unconstitutional, that means Constitutional Court is on our side. So we went there victorious, and indeed we made that history that domestic workers were covered by COIDA. Constitutional Court even said with immediate effect. So what I also explained to Sylvia when I started with the case, I explained to her that, Sylvia, I want you to know that this is not about your mother, only your mother. Yes, I want you to know that with the death of your mother, we could take the Minister of Labour to court, but you must also know that this is about all the domestic workers of South Africa. And we even told our lawyers that we wanted to be backdated UIF from where we got democracy. And I remember there was a time when the Minister's defense said they wanted to backdate COIDA for 3 years. And that 3 years was not even covering Mahlangu, if you speak of 2019 in court, saying 3 years was not including even Maria Mahlangu. But because of our lawyers were so competent, we got that ruling, and it said back to 1994, that's where we wanted the case to go, where we got our democracy, got our freedom as South Africans. And I want you to know that that has opened so much space for domestic workers. I don't know how to express myself, the excitement. I know that this is only the beginning, like Kileuhile said, that this is only the beginning, but now we know that the law is covering us. We are just waiting for that signature. And you will never believe how many cases I get from phone calls I get from relatives of domestic workers who died while on duty, and those who got injured at work. I can make just example with 3. The one was in 2001. They broke into a house here in Pretoria. The domestic worker was killed there, and went to look for those employers. The deceased son came here in Pretoria. He's from Blackstone. We went together to Vonnerbom to look for the employers. We found that they sold the place. They are no longer there. But the papers that he's got from the police explain everything what happened in 2001 when his mother died. The other one, the tank fell on her. That was in 2007. She died on duty. The domestic worker employer's tank, I don't know where was that tank, or on top of the house or where, but it fell on a domestic worker and she died. They are still trying to find employers so that we can maybe speak with the employers that from at this moment, the employers are not going to pay anything from 1994 up to now for those domestic workers who died in the past. This is the government that must take over. That's what the Constitutional Court says. So we need to just find employers, those that we get, and sit them down and explain to them, those the domestic workers who died while they were on duty, that we are not getting you arrested, or you are not going to be arrested or getting sued or thrown into court. We only ask your affidavit that the domestic worker indeed died here, the tank fell on her, or the domestic worker was injured here at work. The third one I want to speak about was killed by a gardener. The domestic worker was working, and the gardener, the employers were not there. She was also looking after the house. I think they said, if I'm not mistaken, it was in 2011. Then where the guy was working in the garden there, opened the music, loud music, when they were breaking into the house, and they attacked the domestic worker with a hammer. She screamed, the neighbors heard her screams, and luckily she managed to try to escape by running away and fell in the street. So the neighbors saw what happened, and the domestic worker could say that this and so has attacked me with a hammer. And before she died, they have had that information. So this is all the information that you are getting, and many cases of domestic workers who died during that time up to 1994. The only thing is that it's going to be a lot of work for us as unions. Many cases will come, and we will need more people to work with us. I wish we can get more people, even in the union. We could afford to get more workers, organizers who can work to get these domestic workers, because now we have found the justice that we were denied for many years, and we have to make this work. And what I also know is that we need employers on board. We have to work with the employers. Today I was meeting with the National Employers Labor Association in Joburg, where we spoke about compensation fund and the way they want to work with us so that the domestic workers can be included in COIDA to assist with the registration, with the employers with registration, because they say some employers might think that this is going to cost them more. They might dismiss domestic workers. And we are saying we don't want that to happen. So we had a meeting with them, and then as time goes on, we'll see that where that will lead us to. But they have promised that they will make employers to register their domestic workers and work with us so that this can work for all of us. Because one thing I want you to know, colleagues, is that the coronavirus pandemic has shown us how much domestic workers are important to many employers. We have domestic workers whose employers were refusing them to go home during the pandemic. They were saying we would rather keep them to our properties so that they can be safe and help us because of the need to have domestic workers, because of the major role domestic workers that are playing in their employers' properties. We have employers even now, when the domestic worker is going home, they hire a Uber or a taxi to take that domestic worker straight home because they are protecting the domestic workers from contracting the virus, also protecting themselves because they need that domestic workers. So all in all, as I'm saying, as in closing that, we are very thankful to Solidarity Center. We are grateful to SERI, Socio-Economic Rights Institute, for everything that they have done to us. And I'm also asking them that they must not abandon us at this minute. They must keep on holding our hands. Let's work together. We made this history together. We fought this justice and we got it together. Thank you all.
Thank you so much, Pinkie, for your presentation. I think it was so important for you to highlight to us the struggle that Sylvia Mahlangu faced in trying to access the courts, in trying to access justice, in trying to access the Department of Labor, because what your presentation illustrated to us is that there are many cases like the Mahlangu case out there, but unfortunately, if you do not have access to a union, to a movement, to human rights lawyers, the struggle in accessing justice becomes unreal for many people, even though we may have it written down in law. It's actually not accessible. And I think your presentation also highlights to us the lived reality of many domestic workers and the voices of many women on the ground, and why it was important to have this presentation along with Myrtle's presentation is that oftentimes we need to remember as lawyers and as academics, and that our work cannot be meaningful if it does not actually highlight the lived reality of women, because then we're just litigating to litigate and we're just producing law that really isn't effective and won't change substantively for women on the ground. And so Myrtle, I want to bring you in relation to the presentation that Pinkie has just done and the journey that she walked with Mahlangu, because like Pinkie rightfully mentioned, there are many other domestic workers who walk exactly the same path, who have exactly the same struggles, and like she mentioned towards the end, who struggle especially in relation to access, because today we're having a discussion and it's a global comparative discussion that looks around laws around the world. And South Africa oftentimes is applauded for its great labor law, its very progressive constitution. But for women on the ground, especially Black women in underprivileged and disadvantaged communities, those labor laws are just merely formal. They're on paper. They don't really affect the lived reality for women. And so we want to bring you in here to tell us, to give us a broader overview in relation to Mahlangu and the judgment. It's a beautiful judgment, but being the union and working with women on the ground, how has it really affected women's lived reality? Have you seen a difference? Can you walk us through what the struggle still means for women today, even after the Mahlangu judgment?
Good afternoon and thank you. First of all, I have to say thanks to Pinkie for going all the way, for walking this way, and for taking it through to the end. We also have to say a big thanks to Solidarity for providing the funding and for being there. To SERI, to Women's Legal Center, to all of you, yes, a big thank you to you. I think all of the midnight oil that SERI was burning, how they prepared their papers, it was beyond our imagination. But we thank you all. But we have to come back to earth now, all the celebrations and all the joy and all the things that has happened. But now we need to come back to earth. And what is that bringing us back to earth? The reality, what Pinkie was saying, the reality of those millions of workers that are without protection, the reality of workers that are phoning our offices, workers that is telling us stories beyond 1994 and even starting at 94. So what is the task of unions now? What is our way forward? We need to understand over the last 6 years since 2012, since 1994, we've just been talking about COIDA, unemployment, wages. We've been talking and talking and talking. We've been bringing domestic workers up to this. We've been educating domestic workers. We do submissions. We did toys. We did demonstrations. We did everything possible to get labor laws for domestic workers. When does COIDA start in 2012? When Pinkie was walking the streets, when we start supporting her as Tatsawu, when she was our organizer, when we were together, we talk about COIDA, but we never went into the insight of what does COIDA mean for domestic workers. So many domestic workers today, they phone, oh, COIDA, what is COIDA? It's the same like Convention 189. Workers didn't understand what's Convention 189. The wages, workers are still don't understand. Why do we get less wages than the other workers? Why are we not important? So unions, and especially the two unions, have got an enormous task. But that does not exclude you, the legal people, you, the academics, you, the people that are doing researchers. We want you really to come on board now. We want you to put, like they say, put your money where your mouth is. So we want you to really start supporting us now. COIDA is there. We can only judge our success if we get that money that belongs to Sylvia, if we're going to know that SERI is going through and won this case, then we know for sure, yes, we can carry forward. Now the problem is this, how are we going to reach domestic workers? How are we going to educate domestic workers? We know for a fact the world has been taken over by technology. The world has been taken over by the digital. The world has been taken over by platforms. Domestic workers doesn't have access to all these things. Domestic workers need data. Domestic workers need good phones. So how are we going to ensure that what was won will gain the domestic worker sector? How are we going to ensure that we educate domestic workers to understand all that clauses that's in the COIDA? It is nice to say, if you fall at your workplace, run to a doctor. If you fall at your work, you, the worker, are alone at home. We have to find a way of when a worker hurt herself at work, she should have access to an emergency number. She should have access to a helpline to say, I've fallen, I'm lying here, there's nobody here, because in the end, it is the employer's word against the domestic worker. So all that things, it's a challenge to the sector. All those things, it's a challenge to all of us. We have to understand there's 1 million domestic workers in South Africa. We are only at the bottom of that 1 million domestic workers. We are only small organizations with little staff to assist, but together with the academics, together with the legal centers, together with everybody, we also have to challenge the Department of Labor. We did a research in Tatsawu, and we asked, how many of you have benefit from unemployment fund? How many of you have benefit from COVID-19? We got answers about 280, no. We got answers from, we have got no access because we have no data. So now the reality is COIDA going to be the same? And is COIDA going to fail the domestic worker the same as the unemployment fund has failed domestic workers? When we have the reality of the COVID-19 now, we find that so many thousands of domestic workers had not got access to unemployment funds. We find domestic workers could not claim the COVID-19 fund. And the reason for that is that so much of the labor laws is still in the hands of the employers. They've got a thing that say knowledge is still in the hand of the bosses. We have to change that. We have to make sure that the laws are changed. We have to make sure that the laws are changed, that domestic workers understand the law. If we look at the reality of the domestic worker, when she wants to claim for unemployment fund, when she wants to claim for COVID-19, She needs to go to the employer. The employer has to sign a form to say that, yes, she is unemployed. Now a domestic worker stays in Khayelitsha. The domestic worker must travel all the way to the employer, take that form. The employer either sign or she refuses to sign. At the union, we want to send that form. We still need to contact the employer. And it's up to the employer if she's going to send that form back. Isn't this exactly what will happen with SCOIDA now? Unless we need to make sure that what we have won and what we've got of COIDA is not going to go into a shelf or into a drawer by the Labour Department. We have to ensure that we make that paper work. And to make that paper work, we have to start educating domestic workers. We have to start educating domestic workers, whether it's on phones, whether it's on WhatsApp, because today the employer gives me quickly a phone because the employer needs me to come in any hours, so I have a phone. We have to teach the domestic worker that importance of that phone. And we are grateful today that Social Law Project and other people is already starting with domestic workers. They're already bringing domestic workers up to this level. We have to acknowledge there is many people that is supporting us. But now let us go beyond. What is the way forward for COIDA? How are we going to ensure that those workers that maybe hurt themselves, how are we going to ensure that we get the evidence? How are we going to ensure that we get the papers to be filled in? We're going to need legal help. We're going to need a lot of people to be involved in this. So for me and for all of us, that's our domestic workers, we would like to see the result of this case. We would like to see that justice has been done for Sylvia. We would like to see that money or whatever will be paid out to them. We would also like to see this hold up of the SCOIDA signature. What is it? We got questions and questions. So 1 minute we know it's gazetted. The next minute we hear, no, it's only going to start. You will only have an answer next year, March. So for me, it's what is the impact of the court case? Why is there still blocking us a lot in the way when it says immediate effect? So kindly, we're asking you, all of you today that's going to listen to us, those of you that are with us, really work the way with us, assist us, help us. Help us. Domestic workers need access to data. Domestic workers need access to many things. And we need your support so that this COIDA is not going to be the same as the unemployment fund. This COIDA has to be ensured that the domestic worker will sit with the employer, fill in that form. The domestic worker will know my employer did register me. We know before with the unemployment fund, the domestic worker said, she never asked me my ID, she never did that. We have to ensure, we also need to understand that the employer needs to pay in this fund. We need to understand that the domestic worker must, ensure the employer. The domestic worker must know my employer. She should have access to the fund. She should have access to know I have been registered and my name is there and my employer is paid. Not purely. Please let us learn from the unemployment fund. Let us learn from the thousands that still not registered. Let us learn. Let us go forward. Let us help the domestic worker to fill in the form. Let us really build on what we have won. And let us really ensure, like you're saying always, when they want researchers, when they want things to be done, they come to the domestic workers. I think there is millions of researchers in the world of domestic workers, but I think the time has now come for domestic workers to challenge each one of you everywhere. Come, help us now. So what Pinkie and all of them has won is not going to be lost. That domestic workers will benefit and that domestic workers will see that they are important and that they will see our work is work like all other work. We also have a challenge. They say, next year you will have the national minimum wage. Are we just going to believe them? Are we just going to sit still and say, and next year we say, oh, what's happening? We need to ensure that we challenge the minister now already. We are going to take all the forms that we're filling in, all the forms, and we're going to make an appointment with the Minister of Labour. And we're going to put it on his table and I say, this is the result of COVID-19. This is the result of domestic workers not being registered. Now we need your answer. What are you going to do? Are you going to prosecute this employer or what are you going to do? So this is our way forward. Work together with us, build together with us. And I'm sure that this time domestic workers will come to the top and domestic workers will be able, because only domestic workers be the change themselves and only domestic workers can free themselves. I thank you very much.
Thank you very much, Myrtle, for your presentation. I think what we can take from your presentation is how eloquently you highlight that we really need to start measuring success differently, especially as lawyers and academics within the legal profession. Because do we measure success because we've got a judgment? Or do we measure success because that judgment has affected the lived reality of women? I think that's a very important lesson for most lawyers who work within the public interest sector and within the human rights space. Because often, like you've mentioned, COVID-19 has changed the lived reality for everyone. And as fortunate as we all are to be able to be on this webinar here today, we have to realize that it's also because we come from a particular class or background that we're able to access this. Domestic workers are not able to access webinars, which is what the space has changed into. When the Women's Legal Center joined the case of Mahlangu in the Constitutional Court as an amici, as a friend of the court, we came and joined the case specifically to speak about litigation within an intersectional and a feminist lens, because only when you look at people's different intersectionality, such as race, class, socioeconomic background, will you then be able to bring about substantive change for women. And one of our biggest pushes, like you so rightly pointed out, Myrtle, is how we measure success, is how we ensure that the judgment becomes a lived reality for women. And I think you take us so beautifully into our next presentation, which is going to be done by Kathy Albertine, who is a professor of law and the South African Research Chair in Equality, Law and Social Justice at the University of the Witwatersrand Law School. And Kathy is going to basically be giving us an analysis not only of the Mahlangu judgment, how far that takes South African jurisprudence, but at a more broader level, speaking to us around feminist litigation and the importance of feminist litigation with an intersectional lens. Kathy, I will hand over to you.
Thank you. Thank you very much. And good afternoon, everybody. And I'm sorry that we're not seeing each other in a room. It's such a strange way of living. I've not gotten used to this. So I want to talk a little bit about the case in the context of feminist litigation more broadly, and how we've got to the space that we wanted to be 27 years ago. We're finally there, and what intersectionality means for what we can now litigate. So it shifts register a bit because it's not really focusing on the implementation of this particular judgment. It's really saying how this judgment inspires us to try and fight for other groups of disadvantaged women. So I think as those of us who were around as feminists in the early 1990s, when we were imagining the new constitution and engaging that constitution writing process, we were reading an awful lot of critical feminist and critical race literature, particularly from the experience of the US and Canada, and we were trying to understand how an equality clause should be crafted, how we could get this thing called substantive equality for women, and that writing pointed us in very particular directions around the language of the clause and how we should really try to be intervening in early constitutional court cases to build the jurisprudence. And in the early 1990s, a young feminist from America came to visit us. Her name was Kimberly Crenshaw, and she spoke at a conference that we organized, and she was very passionate about intersectionality, which we'd read about, but not everyone at that stage was calling it intersectionality. They were talking about multiple voices and multiple forms of discrimination. Kimberly's the person who really gave it that name, even though many particularly Black feminists and lesbian feminists in the States, were beginning to talk about the need to understand that different groups of women experienced inequality and disadvantage differently. But we really learned three things that we thought as feminists needed to be taken into academic debate and into the jurisprudence. The one was context, that unless the courts could put themselves, or the judges could put themselves into the shoes of women and understand the lived reality of women's lives, they would not be able to adjudicate fairly in favor of women. So we very much were pushing in everything we wrote and said is that we don't want abstract analyses. We don't want the formalism that we now see in Jafta's judgment, but more of that later. We want contextual analysis. That was the first thing. The second thing was this idea of remedying disadvantage, that at the core of equality should be this notion that we're remedying multifaceted disadvantage of groups. It's not about concern and respect on its own. That's very nice. Equal concern and respect tells us that the government has considered your case and possibly rejected it. Remedying disadvantage means that you've actually got to deal with people's lived realities. That was the second theme. And the third theme was, of course, intersectionality. So the clause enabled that, right? And it was very clear that the language that unfair discrimination takes place on one or more of the following grounds meant that courts could always consider not just women, but could consider Black older women, or could consider Black rural women, or could consider Muslim women. That was always possible in our jurisprudence. Also, the early development of the jurisprudence, even though the cases were not initially about disadvantaged women, there were people like Cato Reagan there and Yvonne Mokgoro who knew the feminist writing, Albie Sachs as well, great feminist Albie, who made sure that the kinds of principles of substantive equality litigation were embedded in the jurisprudence early on. So the idea of contextual analysis was there almost not quite at the beginning, but very close to the beginning. In Brink versus Kitsoff, which is one of the first cases dealing with insurance, it's a very kind of formal equality, middle-class problems case. But Cato Reagan in a separate judgment made very sure to speak about the fact that we're not following the American road, that we're concerned with substantive equality and the kind of multiple harms that different groups of women experience. It was very clear that patterns of race and gender disadvantage were one of the key, or remedying those were one of the key purposes of the Constitution. And disadvantage was put into the test. It wasn't the kind of the measure of the test that went to dignity, and I've written a lot about that. But disadvantage was put into the test. So it was an asymmetrical test. Equality should not be used by the privileged to shore up advantage. It should be used by people who lack power, who are disadvantaged, in order to help remedy the disadvantage, which is exactly what happened in the Mahlangu case. So of course the jurisprudence didn't develop as we had hoped. There were some terrible cases, right? We know about those cases of Jordan, cases of Fawkes versus Robinson, where even though the applicants were more middle class, the evidence that was placed before the court was very much evidence of disadvantaged, poor, Black, marginalized women. But the courts were very resistant to recognizing those groups of women. But there were nevertheless many cases where, although the court was not using an intersectional analysis as they began to develop in Mahlangu, they were nevertheless granting protection and remedies to intersectional groups of women. So all of those cases on customary law, right? That's an intersectional group of women. It predominantly affects Black rural women, Black urban women as well. Predominantly affects poorer women. So without question, it was targeting a particular group of women affected by multiple axes of disadvantage. All those really important cases, even till today, on women living in Muslim marriages, also actually an intersectional group, women who were disadvantaged by religion and gender and class often. So again, without developing the jurisprudence on intersectionality, it was there. But, you know, so you brought your group along, and if the court was sympathetic, the court would sort of go with the group. So the court always held open the door to developing a more sophisticated feminist jurisprudence on context, on disadvantage, and on intersectionality. And Albie Sachs, of course, who had read as much feminist jurisprudence possibly as the rest of us, in a minority judgment that's actually cited by Margie Victor in the Mahlangu judgment, opened the door to this by alerting us to the two ways in which, as lawyers, we can build intersectionality into our cases, right? And they should be overlapping ways. We shouldn't be choosing between the two. So the one is that we build intersectionality by how we identify the group. So we very explicitly don't say this is sex or gender discrimination and this is a group of women. We say, no, this is a group of women who are disadvantaged by multiple axes of discrimination. And we identify that very clearly. We say these are the grounds that matter. So in Mahlangu, the Women's Legal Center, and others come in and talk about sex, gender, race, and social origin as an aspect of class or social status. So you're beginning to introduce the very powerful notion of intersectionality, right? Which is that for Black women, disadvantage is not the disadvantage of white women and a little bit extra. It is qualitatively different. It's not, these are not kind of gender plus, right? Race and gender creates a qualitatively different form of disadvantage in different circumstances that we need to understand. If you're putting race, gender, and age together, you get the plight of African widows, right? Who are often disadvantaged in particular societies. So you put your grounds together very carefully. The court hasn't always helped that, because the courts often said, well, it's sufficient that it's on one or more ground. We don't particularly care. If you just show us gender, we'll go with Black women. So, you know, they've not been very helpful, but that's okay because we haven't needed it. We've won cases despite the absence of a sophisticated intersectionality analysis. So that's the grounds. And then linked to that is the real importance of context. And that's a lot of hard work for lawyers because it involves a lot of research. It was really well done in the Mahlangu case, where you define the context, which is a very deep and close examination of the situation of the group that you have presented to the court. Their history, you know, in the Mahlangu case, you will see that there's a discussion around how the disadvantage of domestic workers comes from centuries back. It comes from the intersection of colonialism, apartheid, patriarchy, which places Black women at the most disadvantaged in the labor market, unable to pursue economic opportunities and pushed into the private sphere to work for nothing or for very low wages in the households of more privileged communities. So understanding that as systemic, as entrenched, as something we take so for granted that we actually sometimes fail to realize there's a problem with it anymore, right? And then taking that into the statistics and the understanding of the labor market, which shows the position of domestic workers in the labor market, how it's a majority of Black women, how they don't get paid a lot, taking those domestic workers into their households and talking about these are often women who are responsible for large extended households, who are not only economically responsible, but emotionally and psychologically responsible for the well-being of the household. So really understanding that context around history and vulnerability, and it gives the court, if you do it well and if the court hears you, because the court did not hear us in Jordan when we tried to put that context forward, quite frankly. But if the court hears you, then the court is able to make a much more sympathetic adjudication. So intersectionality is very much suggested as being group and context. But it's only in Mahlangu, and it's surprising to me in hindsight that it really took so long. But maybe this is the case where it needed to be argued. And this is the case where the judges, and particularly Acting Justice Margie Victor, was sympathetic. And maybe it was partly because she wanted to overcome the easy answer of Section 9.1, right? So if those of you who are familiar with the case or are familiar with equality will know that there's a threshold test in equality, which is a rationality test. So if there's a differentiation without a legitimate purpose, then it violates the equality clause at the threshold level. It's unconstitutional, goodbye. Okay, and that was true in the case of the Mahlangu case, that the exclusion of domestic workers from the definition of employee had no legitimate purpose, and government said yes. They threw up their hands and said, we have no opposition here. We can't justify this. We understand. In fact, we give up, and didn't really oppose the constitutionality. I think they fought a little bit on the retrospectivity. So, you know, and that's where JAFTA went, right? So JAFTA, a very formalist judge. Does that give me 5 minutes? Yeah, thank you. JAFTA, a very formalist judge, basically said that there is no such ground as domestic workers. I don't understand this at all. There's no discrimination on the basis of any problematic ground, so it's irrational. He wouldn't even go to unfair discrimination because he couldn't see behind the group of domestic workers to see that there were multiple grounds operating to make domestic workers vulnerable and powerless and disadvantaged, which was race and class and social origin. But the majority went for that. And I think the majority felt that in the face of that kind of formalism, they needed to articulate a very strong and clear jurisprudence of intersectionality, and they do that, and they really endorse intersectionality as a feminist contribution to legal theory. And I love the way that the Women's Legal Centre's heads of arguments are very explicit. This is feminist. This is about women's disadvantage. This is about transformation for women. And the judgment picks up on that language and uses it in the judgment and says this is a contribution by feminist legal theory. It's about understanding intersecting axes of disadvantage to reveal the deep historic and systemic harms. And it's about understanding the situation of domestic workers as interlocking systems of oppression. And I've spoken a little bit about how that happens. So it's like now the kind of go-to case for if you're preparing a case on intersectionality. But and you can go and read it. And as I said, it involves a lot of research, a lot of work. You've got to have your facts. You've got to marshal your sociology and your historians and your statisticians, and you've got to put the full picture before the court in order to be able to argue it. But if you can, why is it important? And I quickly want to end with 4 points. One is that I think it renders visible what is often invisible, which is that disadvantage is not just about gender or race or even class. It's often about a kind of multiplicity and an intersection on all of those, right? And I've spoken about that before. So you can start to bring to court very particular groups of women and other people who are excluded from the protection of law. So you can rethink a sex worker case. You can bring migrant workers as a category, informal workers as a category, farm workers or seasonal workers. You can begin to think Black lesbian woman, Black transgendered woman. You can begin to think how very particular categories of women might be disadvantaged in very particular ways, and you can put them into the spotlight of adjudication, and their disadvantage becomes a rights violation, which I think is very powerful. And we heard from Myrtle Witbooi how powerfully that judgment affected domestic workers in terms of the recognition of their citizenship and their rights. So that's the first point. The second point, I think the other way you can think about using it is that it's a different way of presenting poverty. So we know that Social Justice Coalition has sort of accepted poverty as a ground, but it's not always going to be easy to do that because judges don't like economic grounds. So you could probably get to the same place through the intersection of several grounds, right? So you can kind of use a poverty ground through intersectionality. That's the second point. The third point, which I think is crucially important, is really to use it in advocacy and policy and research. Some of the most fascinating work in feminist legal theory is where you take an intersectional group of women and you explore how they are excluded from the protection of law, whether it's immigration law, the unemployment insurance fund, which we've also heard about, how domestic workers are still excluded from the protection. And you begin to understand the barriers that face different people and what that must lead to. And then fourthly, and again, I think being illustrated by the previous two speakers, is that an intersectional approach centers the voices of the marginalized. And it means those are the voices that you must listen to and pay due attention to, their particular plight in crafting your litigation strategy or in seeking out problems that affect different groups of women. And it's not just identity politics. I mean, it's of course, #intersectionality has become a political label for a form of identity politics that represents often young Black women. And that's important. But the legal use of intersectionality is quite different. It's a much deeper understanding of very particular groups and their structural inequalities and disadvantage. So we have to separate the sort of use of identity politics from the way in which we use it in law. Final point, of course, it's not always going to be easy because it often raises tensions between single issue movements on race or gender or religion or nationalism and the multiple intersecting groups of disadvantage that are within those. And sometimes those differences are going to have to be navigated, and sometimes they're going to be strategic compromises. Sometimes you might go for essentialism because strategically it works, which is to proceed on one ground, not intersectional grounds. Sometimes you're going to have to proceed on intersectional grounds. But it's a fabulous legal tool to the feminist arsenal, to use a not very feminist metaphor. It's a fabulous legal tool to the feminist arsenal that we really have to work in, and that we must share with all of those who are not feminist, because I think it works for all kinds of disadvantaged groups. So I'll stop there. Thank you.
Thank you so much, Kathy, for your presentation. I think it was deeply insightful, in particularly in the manner that you ended off by stating that once again, intersectionality is about centering voices, putting those voices up front, and it really looks at the way we, as lawyers within the human rights sector and within the social justice sector, and in the manner in which social movements, instead of litigating from a top-down approach, we really use the bottom-up approach by centering the voices, putting the voices up first, and also highlighting that this is really a multi-pronged approach. Using intersectionality is not just in the courts, but it's also within the research, it's also within the advocacy, but that within the legal use, intersectionality does have a deeper understanding of that structural inequalities, and that even though Mahlangu is a great judgment, your presentation also highlighted to us that we have a long way to go in the understanding and the application of intersectionality among judges, lawyers, fellows, academics, researchers. We really do have a long way to go in understanding and unpacking and applying intersectionality. And Mahlangu is really only the starting point of reimagining cases like you have mentioned. And once again, your presentation shifts us so nicely into the next speaker, who is Natalia, a Brazilian human rights and social justice advocate and researcher. Natalia led the drafting of an amicus curiae brief, which prompted the Inter-American Court of Human Rights to recognize the systemic breach of the right to equality and non-discrimination on the basis of gender, which led to further human rights violations in the 2020 fireworks factory case, a dimension that had not been identified by the Inter-American Commission before the case. And so Natalia will be giving us basically a global comparison of this litigating with an intersectionality and a feminist lens, as pointed out by Kathy, and this global comparison specifically focusing on women working within factories as using the study of the fireworks factory case as a case study.
Thank you so much, Chrissy. And thank you to the Women's Legal Center and to Ziona for inviting me into this conversation. It's an honor to be here and learning from all of you. I had knowledge of the Mahlangu case before, and I really admire all the work that has been put into it and kind of constructing around this issue in South Africa. So it's an honor here to be with you. And I hope I can bring some contribution by presenting a different case on workers' rights, which was framed around the issue of intersectional discrimination and inequality, which was decided by the Inter-American Court of Human Rights last year. So I'll start by giving you a little bit of context about the Inter-American system, workers' rights in the Inter-American system, so you can have an idea of how that differs a little bit from South Africa and how that affects the case. And I'll discuss the case a little bit and then try to draw some comparisons between Fireworks Factory and the Mahlangu case. So the main human rights instrument in the Inter-American system of human rights is the American Convention. And it is strikingly different from the South African Constitution because it's very focused on civil and political rights. It has one article in which it mentions economic, social, and cultural rights, which I will put right now in the chat if you want to refer to it. that talks about the progressive realization of these rights. It doesn't even mention these rights, but refers to rights, the rights implicit in the economic, social, educational, scientific, and cultural standards of the Charter of the Organization of American States. So it is kind of a reference to that, and it had posed considerable challenges to the Inter-American Court in the interpretation. So at first, due to this progressive realization interpretation, the Inter-American Court of Human Rights used to think that socioeconomic rights, including labor rights, were not justiciable in the court. And that was the view until things started shifting in 2009. So in 2009, we have a case which was Acevedo Buendia versus Peru, which declared that although this was not justiciable, these rights must be subject to another article, which is Article 1st, Paragraph 1 of the convention, which I also just put on the chat, which is the article about obligation to respect without any discrimination. So with this case, it was introduced just not an obligation to exactly fulfill these rights, but in approaching them, do not incur in discrimination. A further development happened in 2017 with the case Lagos del Campo, in which the court recognized the full justiciability of socioeconomic rights in a workers' rights case. So a union leader was arbitrarily fired and went to the Inter-American system to get protection. And the Inter-American Court decided that since his country, Peru, recognized job equity, and there were several human rights instruments that recognize economic, social, and cultural rights, that it should be taken into account and it should be justiciable within the Inter-American Court, and that he should have received effective judicial protection in Peru. And that evolved further in 2018 with Poblete Vilches, which was a case that determined that states have also obligations to take immediate steps in regard to socioeconomic rights. It was a case that decided that states have responsibility to adopt to provide essential healthcare, for example, as an immediate obligation. That is not progressive realizable. So there was a very recent development of the socioeconomic rights cases within the Inter-American Court of Human Rights, and that's when we find just 2-3 years after the fireworks factory case, which was also an enormous development in the jurisprudence. So what happens in fireworks factory is that there was an explosion in a very poor and unequal city in Brazil. And this explosion happened in an irregular fireworks factory, which was very high risk. And which had terrible working conditions. So it was completely irregular. There was no security whatsoever. And this explosion happened and 64 people died, 6 were injured. And this case was brought to the Inter-American Commission of Human Rights, who couldn't reach a settlement with Brazil and the victims, and therefore referred this case to the Inter-American Court. The whole background of the case is based on the fact that the government had complete knowledge of the existence of this factory and of a whole industry, a very irregular industry of fireworks production in this region that did not comply with worker rights, with security norms, or any type of regulation. And this was public knowledge and was acknowledged by the government, and it failed to inspect this factory, which led to these violations related to this explosion. It also concerned the lack of judicial protection after these violations occurred. Brazil failed to remedy the violations that occurred. A new argument that was very key, introduced by the Inter-American Commission in its report to the court, was that actually the reason why these workers were there was poverty. They were compelled to work there because they did not have any further opportunities. The whole city was organized around fireworks industry. It had a very unequal history related to slavery. Most of the population was poor and therefore could not find any other types of work opportunities within that framework. And that Brazil, therefore, since poverty was directly connected to that violation, there was a nexus. So it asked for the recognition of a violation of Article 26, and more specifically of equitable and adequate conditions of work in relation to Article 1, Paragraph 1, which is anti-discrimination. And if you look at Article 1, Paragraph 1, it has a non-exhaustive list of grounds. And in this case, what the Commission did was introduce the ground of poverty. So when we started working with this case, we realized that there was something probably missing in this analysis, because all victims were either women or children, mostly girls. And we started researching this context to kind of bring a more complete context to the court's analysis. And that's when we decided to focus our report on how these violations were gender related. So if you look at the context of the city of Santo Antônio de Jesus, which is the city where these violations occurred, you see that 74% of women, for example, and that 74%, of those people who receive less than a quarter of the minimum wage were women. There is a very severe socioeconomic gender inequality, and gender inequalities in general are behind that, behind those issues and those disadvantages faced by women. There were main factors involved in this. First of all, there was an absence of training and further opportunities for women, which was very grave and different than what happened to men in the same region. And second, we saw some gender dynamics playing into these factors. So for example, the existence of gender stereotypes. The fireworks factory work is very simple, it's very rudimentary. And it was understood that that this work was so simple that it could even be performed by women. They were not given other opportunities because they were also understood not to be capable of other types of work. A third element of that is also the unequal division of unpaid care work. So the reason why there were so many children in that factory is because there are no other opportunities in that region that allow women to take care of their domestic and care activities while they work. And since men do not take care of the children, they had to. And they had to either take their kids to the factories or to bring fireworks production, which is very, very dangerous, into their homes. So that was the context. And that's how kids got into child labor because of those issues related to unpaid care work. And that's the context that we demonstrated. When we see the interviews done with these women, we understand that this has been going for several generations, for decades. We see people saying, you know, my grandmother used to do this, my mother used to do this, I am doing this, and my 5-year-old daughter has already started. So this is something that goes from generation to generation, especially because this activity is, although very dangerous, very low paid. So for example, to be able to earn around $300, for example, a person would have to produce 1 million traques, which is one of the products of the Brazilian fireworks industry. So 1 million units of a product in order to be able to have $300. And that continued the cycle because the kids had to participate in order to help their moms and their families to earn more income, and that continued. So that's the aspect that we brought to the court's attention. And the court did not only embrace this argument that these violations were gender related and that they started in the systematic neglect of Brazil to address socioeconomic gender inequality, but it also recognized the intersectional discrimination faced by these women. Firstly, on the grounds of poverty, as had already been argued by the Inter-American Commission. Second, in the grounds of gender, as we had argued, and also on the ground of race, which was a new element that the court found in possession of the data from the cases. So it highlighted how these historic inequalities had played into this confluence of factors that made it possible for this factory to operate in that region and that compelled these people to work there. And the court emphasized how this specific vulnerability of these Black women and girls who were living in poverty emphasized the state obligations in relation to them. And therefore Brazil had neglected its duties related to providing the right to equitable and satisfactory conditions of work without discrimination on the intersectional grounds of poverty, race, and gender. So this has been a very remarkable case in the inter-American system. And I'll talk a little bit now about how it differs from the Mahlangu case. First of all, correct me if I'm wrong, I will try to say a little bit of my impressions, but the Mahlangu case have a very specific object because there was this explicit exclusion of domestic workers from a benefit. And in the fireworks factory, the situation was a little bit different because the challenge was proving that there was a systematic neglect and a failure to adopt these measures, these progressive measures, that had a causal connection to this outcome of the explosion and of women and children dying in the fireworks factory explosion. The biggest challenge was to both make the court understand this overall context and also convince that Brazil failed to take action in related to those issues. So it was a little bit of a different case, and maybe it can provide some insight into further claims related to intersectionality in South Africa, which might deal with more systematic issues and neglect and failure to adopt positive measures. Another difference between these two cases is that while South Africa is very famous for having the provision of one or more grounds of discrimination, so therefore explicitly kind of welcomes into its interpretation the issues of intersectionality, the inter-American system is remarkably difficult because although it doesn't adopt an express list, it has an unexhaustive list of grounds that may be breached. It doesn't have this equivalent embracing intersectionality. The good factor that helped this case was the existence of a previous one who had already discussed intersectionality in 2015. So it wasn't the first intersectionality precedent, but it was the first one in the context of workers' rights. Perhaps also because it wasn't the first case. One remarkable difference between the case in South Africa and the case in the Inter-American Court is that the Inter-American Court does not deepen into the concept of intersectionality. There isn't much of a sophisticated analysis. It talks about the context and the context that we try to bring forward, but it kind of does not deepen into what specific confluence of factors and how these things interacted in a theoretical perspective. So it's more contextual and it talks about intersectionality, but it doesn't necessarily define it very specifically. And I would say that the last and most important difference is that we have been talking about how these decisions affect workers on the ground and how they affect the lived realities of people. And while in the Mashiane case, there was, in theory at least, access granted to this benefit, which of course has to be worked out, but there was this provision of access. Unfortunately, the Inter-American Court failed to make any provisions regarding remedies, compelling Brazil to take measures to address gender and race inequalities. So these measures were more related to compensation, to a public recognition of these violations, but there were no obligations to take positive steps imposed by the Inter-American Court. So we have to see what the impact of this will actually be. But I'm afraid that for the women in Santo Antônio de Jesus and women in the fireworks factory industry, unfortunately, the impact of these decisions might be very limited. And it is something that I think that we have to work out in the inter-American system, as I do think South Africa also needs a lot of work. So these are the main contrasts between the two decisions. And thank you so much again for this invitation and for this conversation. I hope that this case helps bring a little insight into workers' rights and intersectionality advocacy in South Africa. Thank you.
Thank you so much, Natalia, once again for that very insightful presentation. I think your comparison and discussion between the fireworks factory case and the Mahlangu case really struck me in the manner in which you said something which we specifically had in our heads of arguments put before the court as well. And it shows us why it's so important to have these global comparative discussions, because something you said is the exact same thing that we said in Mahlangu, where we basically put before the court that once again, it is women's work that is deemed undervalued, underpaid. Like you said, it was specifically, the discrimination resulted specifically from the fact that it was deemed as women's work. It was deemed as something that's as simple that women can do. And so like we had mentioned here for domestic workers, it was once again an illustration that, and it brings us to that historical standpoint that women's work is less of value, it's underpaid, and women's care obligations are often not taken into consideration in relation to the labor environment, both in informal and an informal work sector. And these are great strides that we still have to make regardless of the laws that we have in place, because that is still the position of women within the workplace today. And in particular, women who come from a specific historical background, disposition, and then are kind of working in these vulnerable and precarious conditions, which further compounds their vulnerabilities. And I think your presentation ended off so nicely, once again, taking us into the next speaker's discussion around, so the importance, I would say, of class action, because like you highlighted within this case, the judgment is great in that it provided for compensation and for the acknowledgement of this unjust and human rights violations, yet it didn't effectively provide for remedies that will speak to and see to the rights recognition and realization of other women who work within the same conditions and within the same positions. And I think that takes us to the issue more broadly around the importance of class action, the importance of a term that has become quite popular, known as movement lawyering, social justice lawyering, and why these are so important. And that takes us to the next speaker, which is Manoj, who is a lecturer in law at the University of Bristol in the UK, and he conducts research on the litigation strategies of worker organizations. His initial research was focused on farm worker movements in Canada and the United States, and more recently he has been examining the litigation strategies of some newer unions in the United Kingdom, which represent migrant workers. And Manoj, I welcome you to please provide us with an overview and kind of an analysis more broadly of how these social movements, broader public interest litigation can engage with the courts effectively to provide for the substantive equality as we have been discussing throughout the webinar.
Great. Hi, everyone. Just bear with me whilst I get some of my PowerPoint slides up. Hopefully you can all see that. Great. So let me be a typical lawyer and start with a set of caveats. I'm not an expert on domestic workers, nor am I an expert on intersectionality. As the introduction briefly mentioned, my research is primarily on worker organizations and their litigation strategies. And the question I'm really interested in is, how does the litigation strategies interact with some of the more political work that all these sort of labor organizations do? And my focus is mainly on sort of unions that represent migrant workers in sort of advanced industrial countries like the United States, Canada, and now the UK. But just listening to all of the speakers that went before me has been very much a humbling learning experience for me. So thank you for the invitation to be here this afternoon. So I'm going to try in my 15 to 20 minutes to try and provide some comparative context about how unions are using strategic litigation in the United Kingdoms. And I'm sort of interested in a new breed of union that's sort of sprung up in the UK. There's three main ones that I'm thinking of: the Independent Workers' Union of Great Britain, the IWGB, the United Voices of the World, and the Cleaners and Allied Independent Workers Union. They're three relatively small unions, and I'll provide a little bit more detail in a second. But what's interesting about them is that they are also at the same time trade unions, but also social movement organizations. And I'll sort of go into a little bit more detail because of the sort of tactics they employ in trying to win gains for the particular constituency that they represent. And so the sort of the theoretical crux of my talk today will be to try and think about how the litigation strategies of one of these unions, in particular the IWGB, interacts with labor organizing work that this organization undertakes. So as I mentioned, I think in the UK, we've started to see a new generation of unions spring up. The three that I've just mentioned, they are relatively new. They've only been on the scene for about, well, since sort of 2010, so roughly a decade. They tend to be small in terms of membership. So I think, you know, the IWGB has 10,000 members, which is not a huge number of members when you sort of take that against some of the much more bigger established unions as in the UK. Some have, you know, several hundreds of thousands. But and they tend to be small but agile and quite confrontational in terms of the way that they carry out their functions. Another really fascinating facet for me, at least, of these unions is the fact that they're made up primarily of racialized workers, right? So, you know, unions in the UK have a long-standing history of racism and have really struggled to organize migrant workers or even second-generation workers from racialized backgrounds. But I think one of the really inspiring things about these unions is this is a population that these unions have set out to target, and they generally do a really good job of bringing these workers on board. Now, there's a bit of a context, I think, as to why these unions have arisen. I think the first context is austerity. You know, the UK was very badly affected by the global financial crisis, and the government response to that was to really socialize private debt and pass the burden on to taxpayers, which led to a decade of really low growth and employment in lots of sectors like the gig economy sector. And you'll find that the membership of these unions tend to be those workers, people that are working as Uber drivers or Deliveroo riders or as couriers or a variety of those things. The other, I think, political context is the hostile environment, right? So the Conservative government here tried very hard to clamp down on what they called illegal working in the labor market, and passed a whole heap of immigration reforms, which had a flow-on effect for even workers migrant workers that were here with, you know, a proper authorization and documentation to work in the labor market. And so there was sort of a rise in racism in workplaces and more challenges. And I think as a result, that caused the radicalization of this particular workforce, right? And of course, the rigidity of mainstream unions. Some of the members that joined these three unions previously belonged to some of the more established unions, found them just very unreceptive, not particularly democratic, and not really interested in taking on the sort of issues that these workers were interested in pursuing. So they sort of left and formed their own unions. So I'll move through these set of slides relatively quickly. The reason I sort of this slide and the next couple that follow, I have this, is to sort of really sort of reiterate to you that I think these unions are quite different in the way that they undertake their work, right? So, you know, traditional unions we know will recruit members and try and engage in collective bargaining with their employer, often using strike action as a sort of leverage to try and get the employer to the table and then the employer to agree on a set of terms and conditions. But these unions see themselves, I think, much more broadly as social movement organizations. and really sort of plays into a debate that's been taken place in the UK since the 1990s about whether unions should sort of organize and try and sort of reach out to new communities and new workplaces, or they should sort of sit tight with the kind of the workers that they currently represent and try and get a better deal for them. And I think really this new generation of unions really takes that sort of engages with that debate and really sort of comes down on the side of organizing. They're very proactive about reaching into new industries, into new workplaces, and into new demographics that have previously not been unionized. So these are just some statistics to give you a sense of what the migrant worker population in the UK is. It's roughly about 15% of the workforce is foreign born. But if you're talking about racialized workers, the proportion is much higher because since 1945, the UK has had reasonably high levels of immigration from countries around the world. Another, I think, really distinguishing feature of these unions is the form of sort of actions they take. So they're quite engaged. This country has very draconian laws on taking strikes. There's a huge number of administrative hurdles that unions need to overcome, such that their strike action can be considered lawful strike action and therefore not subject to employer reprisal. But I think what some of these unions do is they challenge some of these laws by just essentially ignoring them and taking action and sort of seeing what the consequences might be. And thus far, that's been a very successful strategy for them. But they also try and organize beyond the workplace. They're very interested in organizing sort of big protest marches, drawing on board allies in the community, and especially in places like London. Got some feedback there. Yeah, so they organize protests in places like London and some of the other sort of major cities as well, and really have been maybe able to sort of get onto, I think, the kind of the public agenda by doing this. Just as some sort of evidence, there's lots of newspaper articles in this that have covered the work of unions like the IWGP, which sort of gives you an indication of how they've been able to, even as a small union, really have a major public impact. Okay, so this is just a quick list of some of the main campaigns that these unions have run. They've been really successful at organizing in the kind of even in the university sector, where there's been sort of the outsourcing of functions, and they've really been able to put pressure on the university central managements to bring some of those sort of functions back in-house. As I mentioned, couriers and Uber drivers and a variety of different places. Now, another really distinguishing feature of these unions is they're very proactive about going to court, right? And that's an interesting, I think, development for unions in the UK. There's a long-term hostility towards sort of common law courts because of the perception that they have not been sort of alive to issues that relate to workers' interests. But I think these unions really take the view that given the hostility they're facing from conservative governments who are not inclined to legislate in their favor, they've sort of used the courts as a kind of a crucial form of leverage. And there's been a number of really kind of prominent cases that they've brought, some going all the way up to the Supreme Court. But today I really wanted to talk about really the three cases, and hopefully it'll become clear why I have brought these cases to your attention in the context of the intersectionality workshop. But the first case I'd like to quickly discuss is this case where about mischaracterization of workers, another case where Deliveroo riders have sought collective bargaining rights for workers, and third, a sort of a racial discrimination claim that the Uber drivers brought in London. So let me quickly just give you a quick bit of background about these cases. I don't think I need to go into too much detail, so I'll sort of just keep it very high level at this point in time. So the UK has a number of employment rights, but the employment rights are predicated on being able to establish either employee or worker status. So we have this odd intermediate status called a worker status that a lot of countries don't have. So we don't have the binary necessarily just between employee and self-employed. We have this intermediate group. They don't get quite as many rights as the employees get, but they get nevertheless an important suite of rights. So really what's been happening is that a lot of the employment that's been created in the gig economy, these are fairly parasitic kind of platforms who thrive on really misclassifying either people who should be classified as workers or employees as self-employed, and therefore not paying them and providing them with the basic employment rights to which they're entitled. And so with regards to the Uber litigation, the two Uber drivers who brought that claim back in 2013 were interested in establishing worker status. They didn't go for employee status, they went for worker status just because the legal test is a little bit simpler to establish. There was an excellent first instance judgment that really looked at the reality of Uber drivers' working conditions, the level of control exercised by the employer, and the employment tribunal concluded that they were indeed workers. And the kind of the important consequence of that was that the Uber drivers were entitled to minimum wage, and B, entitled to be paid for all time that they were logged into the app, not just the time that they were ferrying customers around the city. This got appealed through all the different levels of the courts and ended up in the Supreme Court. And on the 19th of February, there was quite a very important decision handed down, where the court really took the position of the court of first instance and said, yes, we need to interpret this work category purposely, and we need to be looking at the reality of the working conditions and working arrangements, and not the kind of the contractual chicanery that goes around. So a very good decision, really. But one has to consider the practical implications, and I think this has continuously come up in the discussion up until today as well. So Uber immediately sort of turned around and said, that decision didn't apply to its entire workforce. It only applied to the very small group of workers, a completely unsustainable position. And then a few weeks later, they sort of changed that and said, actually, now we've decided to comply with the decision. We'll provide minimum wage, but we've decided to ignore that facet about paying them for all hours logged into the app. So which really sort of nullifies the impact of that case if you think about it, right? And so really there's going to have to be another whole set of litigation to try and get that judgment enforced. So and just to sort of think, the case was originally brought in 2013. It took until 2021 to get a proper judgment, and the realistic prospect of that we're all facing is another kind of bruising, lengthy process of litigation to get an outcome. So the practical implications are, difficult, and we need to keep that in mind. I won't go into too much detail about the Deliveroo litigation. Very much the same thing here. The workers were trying to get again recognized as workers, so that they could get access to collective bargaining rights. They had a bad first instance decision, but now it's before the Court of Appeal, and the hearing's been heard, and we're waiting to see what the Court of Appeal will do. And people are hopeful that the outcome will be good, especially given the Uber Supreme Court pronouncements in the Uber decision. Another set of litigation that that IWGB has really pursued is trying to think about the lived experiences of these workers who are racialized. As I said, 90% of their membership is racialized. And there was a decision by the London mayor, arguably for laudable purposes, to implement a congestion tax to cut down on congestion and environmental degradation. The only problem was this: the way that the congestion tax was implemented, it would target the Uber drivers, but leave their existing cab force untouched. And the problem with that is that the Uber drivers, the private hire vehicle drivers, are 94% from Black and minority ethnic backgrounds, whereas the traditional kind of cab workforce is primarily white. There's also a huge sort of class issues at play here. Most of the people who drive Uber cars and a variety of other companies that are engaged in a similar business, the drivers live in some of the most deprived parts of London, and they have very low rates of pay. Their salaries are 23,000 would be a good salary for them, far less than that often. So it does seem to, that decision seems to place the congestion tax policy seems to place the Uber riders at a particular disadvantage. And it's for this reason that the IWGB sought judicial review of that decision on the basis that it was a form of indirect discrimination. And essentially the mayor of London agreed that it disadvantaged BAME riders, but argued that it was for a proportionate and a legitimate purpose. And the High Court found that yes, it was for a legitimate purpose, reducing traffic and congestion, and it was proportionate because only a small area of London was considered. So a very formalist kind of interpretation of the statutes, a real reluctance to sort of look behind the kind of the surface and see the reality of intersecting identities and multiple forms of oppression faced by these workers, and the outcome wasn't great. So at the Court of Appeal, as I said, the appeal was dismissed. So I think what we're starting to see is that even though these unions are very proactive about bringing litigation, they practically have a lot of problems associated with that. So the question I ask myself is, why are these radical unions who are also willing to do so many actions on the streets undertaking this litigation that seems to ultimately go nowhere? And my thinking on this is that there is a connection. It is not the case that my intuition is that it's not the case that these unions are going to court simply to get a result. They're going to court because the act of strategic litigation has benefits, indirect benefits, outside of merely the kind of the court ruling itself. I'm at the beginning of a research project, and unfortunately the coronavirus has sort of thrown that into a little bit of disarray. So what I've recently done is I've sort of, informally spoke to a few people, looked quite deeply into the work of these unions and developed sort of a conceptual think piece. And my aim is to spend some time in the summer to go and speak to workers themselves who are union activists, to ask them how they see the act of litigation and what it's done for them. So I draw on a literature called the law and social movements literature. I think some of you in this seminar might be familiar with it. It essentially tries to think about the litigation strategies of social movements and understand it sociologically. Let me just, it is I find it a very helpful literature to kind of make sense of what's going on with the IWGB. And so this sort of thesis I have that the IWGB is going to court because of the indirect effects of the litigation rather than the direct effects really is one of the kind of the core findings from that literature, right? I would say that the law and social movements literature it's a very United States-based literature, but it's certainly starting to be employed by people all around the world to sort of think of and understand how social movements operate. I find a South African scholar, Chepo Madalongozi, a really sort of insightful practitioner in this area. He's a really useful thinker whose work I used quite a bit in some of my own work. So it is having an impact beyond just the United States right now. So my thesis is basically this, and this is the sort of impression or intuition I've gotten from my initial study. As I said, it's yet to be confirmed empirically by qualitative work that I intend to undertake over the summer, fingers crossed with some of the coronavirus restrictions easing. But essentially, my thesis simply is that we need to be thinking about this litigation very sociologically, in workplaces that the IWGB organizes. There are all sorts of divided subjectivities. These divided subjectivities come about because of different legal and social categories. You've got, race and gender, those sort of social categories, but you've got lots of legal categories that create sort of divided subjectivities as well, right? So temporary workers versus permanent workers, migrant workers versus domestic workers. So just a variety of different subjectivities, which you need to cohere a collective identity for the purposes of labor organizing. So labor organizing is very much based on this idea that people in a particular workplace need to see themselves as a part of some common endeavor. And really what I think the litigation helps to do is to sort of cohere that collective identity of these workplace participants as workers who are deserving of dignity, who deserve rights there, and they're engaged in sort of a common purpose together. I'm not saying that that helping cohere this collective identity is sufficient for sort of the labor organizing, but I do think it is a necessary condition. And really what we need, and it helps lay the groundwork to develop sort of the cultures of solidarity that you need in a workplace for labor organizing to take place, I think. And those are the sort of initial observations that I've had about the role of the litigation in the context of some of the labor organizing work. As I said, I am planning to do some qualitative work over the summer using this methodology called narrative biographical method, which is where I sort of extensively interview workers and ask them in their own words to talk about how they see an event such as the litigation in terms of their own personal biography and coming to of political consciousness. Hopefully I'll have the chance at some future date to update you on what the findings of my research are. But look, I think we're running out of time, so I will wrap up there. And yeah, thank you for your attention.
Thank you so much, Manoj, for your presentation. I think it, once again, is so interesting to make the linkages from where we started with Mahlangu and now ending with your presentation on the importance around unions and social movements in regards to strategic and public interest litigation. I think what you highlighted so eloquently was once again how there's this imbalance within the work environment, particularly within the informalized workspaces, which has created this push and this need for unionization and social movements. And I think a term that has been quite popular over the past few years in relation to litigation is a term called movement lawyering, which some of us then also call feminist lawyering, and which bridges then this kind of intersectional litigation and manner of litigating by centering voices, as some of the speakers have mentioned earlier as well, but also as you highlighted, this importance of collective identity, but being aware of differences. Once again, if we bring that back to Mahlangu, it's once again it was about Sylvia Mahlangu and her case, but it was this collective identity of all domestic workers being excluded in terms of this, in terms of these rights, in terms of these social security protections, but being aware that not all domestic workers are the same, and not all Uber drivers are the same, and not all factory workers are the same. And once again, with an intersectional approach, not every one woman is the same woman or not a homogenous group, and that people face discrimination based on their different intersectionality. So thank you so much for your presentation. I'm aware of time, and I'm aware that it is also late in the evening here, but early in the morning for some of the other panelists. But I do want to just open the floor up for any questions or comments that anyone might have had. And if not, I will hand over to Ziona, who can just conclude the session for us if there are no further questions or comments. Siona, I think that's an indication of how really effective all of the panelists were in their presentation. So I'll hand over to you.
All right, well, thank you all very much for your presentations. They were fascinating. Just to, we're running out of time, just to quickly recap. So we started off with Pinkie and Myrtle basically describing the process of the litigation in this case, and Pinkie emphasizing how important visibility was, which sort of goes back to what Manoj just said. Visibility was key in the success of Mahlangu for domestic workers. We heard from Kele about the beyond beyond Mahlangu. Now we need to be able to actually make claims in terms of this case. We need to make sure it's effective and successful on the ground. And as it stands, the limitation of 1 year within which to make retrospective claims does not feel like it's justified under the decision and under the rhetoric around intersectionality. Then we heard from Kathy about that how South Africa was always focusing on substantive equality and context and group disadvantage, but that this is the first time that the court has consciously adopted an intersectional lens, and that it's a powerful tool, a powerful feminist tool to be used going forward. After that, we heard from Natalia, the very fascinating American court decision about the fire factory, which was also found to constitute intersectional discrimination on grounds of poverty, gender, and race, and how there it was systematic issues of neglect that were being adjudicated. And the question of what positive measures mean in terms of remedy is sort of left open, and we're not sure how concrete that is. And then the final speaker, Manoj, talking up to the small indie unions who are using innovative tactics. One of those tactics is engaging courts, sometimes with success, but oftentimes not with that much success on the ground. But nonetheless, there are these indirect benefits which come from sort of group identity and solidarity, which I think is really interesting and also rings true for my involvement in Mahlangu. I remember throughout the years, this case took a long time to get to the Constitutional Court. I remember at one point having a conversation with somebody and saying, well, if Mahlangu never gets to the Constitutional Court, I still think it's achieved success. And I think it was these issues that Manoj spoke about, solidarity, identity, that sort of litigation helped achieve. So with that, I'd like to thank you all for coming, for participating, and I hope this is a conversation we can continue. Thank you very much.